Good morning, everyone. Happy snowy Tuesday, and welcome back after the winter break. My name is Amanda Perazio. I am the Chief Human Resources Officer here in Jefferson County, and I'm glad to see everyone has arrived safely. And for those of you who are driving and listening, please do so carefully. For those of you who are working and listening, please do so carefully. And for those of you who are still warm at home, please have a nice day and stay inside. Trust us. We would like to welcome the teams back to the negotiations table after our winter break. Happy New Year to all of you. Happy New Year to those of you who are tuning in. Before we get started, we would like to go around and do introductions. And so I already introduced myself. So let's start with Jen and go that way. And if you could just say your name and your role in Jeffco, that would be great.
I'm Jen Christensen, the Director of Labor Relations.
Sarah Smith, Preschool.
Nikki Saunders, Health Tech.
Xander Kashub, JESPA President.
Darcy Hassler, Paraprofessional and JESPA Bargaining Chair.
Tiffany Beestrom, Paraprofessional and Building Rep.
Vicki Flores, JESPA Staff.
Mike Hins, Director of Fleet Services.
Brandon Rude, Manager, Dispatch Operations.
Katie Jeter, Director of Resources for Food Service.
Thank you, everyone. And joining us is Sue Ann Holly, the Director of Early Learning. And we will go ahead and move forward. We have a couple of team members who are still joining us as they are driving in after dropping off kiddos and trying to do so safely. So our agenda, I'm going to share my screen so that viewers are also able to see the agenda. And so our agenda, as on the screen, we had our welcome and introduction scheduled, and then we have 3 language proposals from each side of, 3 from the district and 4 from JESPA. And those articles include 10, 12, and 13, and then 1, 2, 8, and 9. We do have caucus time scheduled as well as a question and answer time. I believe we do want to add in a couple of things. We wanted to discuss facilitation, and then there's a scheduling conflict that we need to review on January 21st. And then, of course, at the end, we will set the agenda for January 14th. Darcy, is there anything else that you wanted to add to the agenda?
There was something that we left from last time on the recorded sessions on how to access them, and I would like to thank Jen that she got right back to the team on that they are on there, but for everyone's knowledge, I would like to say that they are on the Jeffco Board Negotiations website. Instead of scrolling down to the bottom where all the different years are listed, it needs to be the top button that says View JESPA Negotiations. And then now they are all YouTube. So that was our mistake, as we all just scroll down to the bottom to see previous ones, but they are at the top. On the left it says JCA, on the right it says JESPA, and when you go in that link to YouTube, then they are there or are being put there for previous years. So I just wanted to acknowledge that Jen did that right away and let us know that it was there and we were just looking in the wrong place.
Great. Great. Thank you, Jen. And thank you to Drew, who's behind the scenes, re-uploading all of those after transitioning to YouTube instead of our previous version of live streaming. The other thing that we were going to add to the agenda just escaped your mind, I can tell. It was scheduling on January 21st. I would also like to welcome Jessica Goodkin, one of the directors of special education, who has just joined us, trying to make people not have to quickly turn on the mic. So any other agenda adjustments before we get started?
We would like to propose a 20-minute caucus after you do your language before we do ours.
That sounds great.
And just, we're not going to do ours 1, 2, 8, 9. I don't know if that needs to be fixed, that we're going to do it in a different order, but I just wanted to call attention to that. And 1's going to be very fluid, and we'll talk about that when we get there.
Sounds good. All right. Any other items before we get started with language?
Again, sorry. And on our Teams folders, we have all the articles, but we don't have appendices. And one of our articles refers to an appendix. So I don't know if we want to put that in the article or just have a way to submit an appendix on our team's channel. And I just wanted to,
Totally. Jen?
I tried and I'm not saying it's anything that's set up wrong. It's a me learning Teams and I was unsuccessful. So I'm asking for some support there, Jen.
Purple is the one I will choose because it is Purple Week. I've claimed it Purple Week. I'm a Baltimore Ravens fan. So it's Purple Week. Yeah. So you know. Okay, so we will go ahead and get started with Article 10. Our approach will be to put it up on the screen and to not read through the entire article unless you would like us to, but to read through the proposed changes that we have identified. So I think I have to switch screens. Okay, so our first article that we would like to present for red lines for consideration is Article 10. Article 10 is our professional behavior and corrective action article. This is the right order, right? You're doing 12. Okay, sorry. I got confused for a second. So Article 10, we would like to propose switching the title of this article from simply corrective action to professional behavior and corrective action, because it really does address both throughout the language. So we have indicated that change both at the title and in the first heading. In 10.1.2, we have proposed switching the language from discipline to corrective action. We've done that a few times throughout this particular article. In the second piece of due process. So in due process, you have reply, notice, representation, and appeal. In the second piece of notice, we've made some suggestions. The right to be notified of a potential corrective action, including the topic of the meeting, and we left in 2 workdays prior to holding the meeting, in order to have adequate time to prepare. So just kind of simplifying it and being more specific around the fact that it would be potential corrective action and that the topic of the meeting would need to be given, of course. In 10.1.2.3 under representation, we have struck the language or an adverse evaluation is delivered. Later on in this article, you'll see that we have suggested moving the language around evaluation out of this article and into the evaluation article. In 10.1.2.4, again, instead of adverse action, we use the word corrective action. In 10.1.3, just cause, in the very first section under adequate warning, we simply changed the language from employees will be informed of rules and policies to employees will be informed of the kinds of misconduct that may result in corrective action. As you all are aware, sometimes misconduct may be against a rule, against a policy. It also may be against a law, against a reasonable responsibility, etc. And so we just wanted to include that word as that section as kinds of misconduct. In that same section under just cause, under 10.1.3.5 and 10.1.3.6, we just had a minor change. Equal treatment, all rules, policies, and penalties will be applied equitably and without discrimination. So we just changed the word even-handedly to equitably. And then 10.1.3.6, instead of saying in Article 10, we just said in this article since it's the article that this language lives in. Again, in 10.2, performance management, we have a suggestion to move this language to Article 9. Therefore, we have not made any specific red lines to this actual language, except to lift it all out, move it to 9, and then once we get to 9, we can review those potential modifications. In 10.2, under employee misconduct, we have, sorry, there's something covering my screen. In 10.2.1, of course, I'm sorry, I forgot to note, throughout we have renumbered, and we know that in the end, Jen will fix all of it and make all the numbers beautiful. But we have, because the following did not seem to be actual steps, we took out that last sentence that says the procedure for progressive discipline will include the following steps. So these aren't really steps, they're just kind of a description of what it might look like. The first paragraph being around prior to issuing formal reprimands, the restorative practice should happen. And instead of using the EAP or district restorative practice staff, we put the appropriately trained district staff. We know that both the EAP, the restorative practices team, and others are trained and want to make sure that we are not exclusive and of just those teams only, because there are others who may be able to do that. In the next paragraph, we have taken out the language, a letter of concern. We feel as though a letter of expectation and a letter of concern really are one and the same. And oh, I'm sorry. Right, just right here. There you are. You're welcome. So we took out the letter of concern, and we're proposing not using that particular type of letter anymore. It's not used very often anyway. And then just very simply, under the formal discipline process, we changed the word where appropriate to when appropriate. In what would now be 10.2.2, we added in some language. So this now reads, in cases of intentional violation of district policy or commission of a felony, the employee is subject to suspension, demotion, or immediate discharge. All three of these things could be true at any given time, depending on what the severity is of the action. We suggested removing the Article 10.2.3, 10, whatever that was previously numbered. So the district may suspend, demote, or discharge an employee for willful abuse of leaves, benefits, or misuse of a firearm. We didn't feel like this fit. It was a really strange, separate thing that was pulled out. Misuse of a firearm would likely be a misdemeanor or a felony, and willful abuse of leaves, benefits potentially lives in the leaves article. We also believe that for the majority of our employees, the misuse of a firearm would be handled potentially in a safety and security section, because those are the employees who typically are using a firearm at work. Of course, there could be also misuse of a firearm off school property, at your own home, etc. But we thought it was strange to call that out separately from all other felonies and misdemeanors. In 10-4, we've made a couple of suggestions. In 10.4.1, all discipline, including termination, may be subject to the grievance process. We added in non-disciplinary actions, including but not limited to letters of expectation, are not subject to the grievance process. So knowing that that is part of the steps of communication leading up to potential corrective action, we didn't feel as though that would make sense for that to be grieved. In 10.4.2, we struck this because misconduct may detrimentally impact performance, the progressive process. We felt like this, if necessary, would need to live in Article 9 with performance management, if that's truly what it's related to. But also, if you read through it, because misconduct may detrimentally impact performance, the progressive process outlined in this article shall not be construed to be mutually exclusive. So sometimes misconduct will impact performance, sometimes it does not. Sometimes it's completely separate from an employee's actual performance. And so we felt like it wasn't necessary to call this out in this particular article. In 10.4.2, an employee may request, instead of the word petition, it just seemed like more simple language, an employee may request that their supervisor classify a corrective action step as inactive for the purposes of progressive discipline if no similar misconduct occurs within 12 months of the date of the first offense. Previously, the language was really ambiguous. It said after a period of time, so there was no specificity to that time frame, so we wanted to add in some specifics. In 10.4.3, this is simply stamping a practice that is already in play. The district may place employees on paid or unpaid administrative leave in response to allegations of misconduct, policy violations, or unlawful acts. And that is a current practice for any employee who may be allegedly under investigation for or have committed one of these particular things. And then in 10.4.5 or 10.4.4, employees participating in restorative conversations, administrative inquiries, and or grievance proceedings will be paid at their regular rate for the time required to attend. So this just really simplifies this language. It says the same thing, that employees would be paid for attending those meetings. We just modified the language to simplify it. And that is all in Article 10. I know that we have caucus time after all three articles. Are there any immediate questions that anyone on the team wanted to bring up? And Jen will drop that article into our shared folder.
Similarly, how we are taking things and moving article to article, I just want to know it, because that's going to have a red line and it's just going to have strike through the portions that you would like to put into Article 9. How are we tracking that that's going to be moved to 9 rather than just striking? Just a process question.
So, I mean, we have a working draft of Article 9 also, and so we've literally just taken that section out and put it into 9, knowing that that is an article that I think you were bringing first.
Correct.
And so I know that might be weird. So when you present 9, when we present it back,
will
exactly, we would put that whole section in there. And then if there are any red lines within that section, we would put those in there as well.
Again, just how are we going to do process? Because we're kind of trying to do the same thing.
Totally. Okay. Any other questions right away on 10? All right. Is everyone okay if we move on to 12? All right. Jen is going to present 12.
Okay, so our next article is Article 12, which is for grievances. We have made quite a few changes in this article. Yes, I can. Okay, for 12-1, we have changed most of the wording here to the grievance procedure aims to resolve concerns regarding potential violations of this agreement in a manner that is fair, formal, and timely. It may be used exclusively to address alleged breaches of the specific articles outlined in this contract. And we struck what 12.1 was originally. We also moved from down below in 12-3, I believe, in general, we moved all of the definitions for grievances. So 12-1-1, we defined a grievance means a complaint made by an employee as defined in Article 1 or the JESPA alleging a violation, misinterpretation, or inequitable application of a provision of this agreement. We also defined class of employees, referring to a specific group of workers who share common characteristics, job duties, employment terms, or working conditions. We defined representative status, refers to the authority, role, or designation of an individual or entity to act on behalf of a group of employees in matters related to collective bargaining, grievances, and workplace disputes. And we defined neutral administrator to referring to a director level or higher who is not connected to the grievant, the department involved, or the specific incident in question. This individual is responsible for impartially overseeing the Step 2 process. We also added, prior to entering into the formal grievance process, with the submission of the Step 1 grievance form, the employee with a perceived grievable concern must first attempt to informally resolve the concern by meeting and discussing the issue with the administrator involved within 5 workdays of the incident triggering the concern. The employee will schedule time with the administrator providing reason for the meeting. The employee may have representative accompany them to the informal meeting. Sorry, I'm having a hard time with that word today. And then we also changed or updated the grievance process shall not be utilized to resolve complaints of unlawful instead of alleged sexual harassment or discrimination. Instead, these concerns should be filed in accordance with the district policy GBA, Equal Employment Opportunity and Discrimination. We did strike GBAA because that is no longer a policy that we have in the district. For 12-2 for procedure, 12-2-1 step 1, we did change it from department level grievance, or we're suggesting changing it from department level grievance to administrator meeting. We struck in order to initiate step 1 and how that will work. 2, if the concern cannot be resolved during the informal meeting with the employee's administrator, a formal grievance process may be initiated no later than 10 workdays after the informal meeting. In order to initiate step 1, the employee must submit a step 1 grievance form to the appropriate school department supervisor. A meeting to resolve the grievance will occur within 10 workdays. So with this, what we've done is we're suggesting that we add a level prior to the step 1 grievance process. The employee and the administrator will attempt to resolve the issue and may present or consider all available evidence at the meeting. We also have added or suggesting to add 12-2-1-1, which is specific to a grievance procedure for hiring folders. Before initiating the formal grievance process by submitting a step 1 grievance form regarding an alleged hiring process violation, a JESPA representative must request and review the hiring bid folder within 5 workdays of the incident triggering the concern. For instance, failure to notify the employee in advance, failure to offer an interview, or the hiring of another candidate. If after reviewing the hiring bid folder, a hiring process violation is identified, the formal grievance process must be initiated within 10 workdays of the review. The grievance must clearly reference the articles, clauses, or sections of the CBA that are claimed to have been violated, explain how the action or decision conflicts with the cited provisions, and include supporting facts such as dates, times, and specific incidents. We are suggesting that we change all of the grievance must name the specifics to be more specific around what we would like to see in the form. At the conclusion of the step 1 grievance meeting, the administrator will submit a written response on the approved district forms to the employee and the JESPA's office, copying labor relations. We did change employee relations to labor relations throughout this document or within this article within 10 workdays. So we've changed, we are suggesting modifying the 5 workdays to 10 throughout. Responding to the issues discussed, we also struck that. We are asking or requesting that the step 2 district level grievance be changed to neutral administrator hearing. And we have updated to if a satisfactory resolution of the issue is not reached at step 1, the grievant, instead of JESPA, may initiate a step 2 grievance with the Office of Labor Relations by filing a step 2 grievance form within 10 workdays after receiving the step 1. The step 2 form must explain how the step 1 response failed to meet the requested remedies, otherwise it will be returned for revision. We also made some changes to the next paragraph that just states Direct filings that meet this criteria must occur within 20 workdays of the alleged violation. And that's when we are filing a step 2 grievance directly for a class of employees that meet this criteria of the alleged violation instead of using offense in the event of an ongoing situation. We also made some changes on the following paragraph. A designated district administrator, district director level or above, unless mutually agreed upon with the JESPA, will serve as the neutral hearing officer at step 2 upon receipt of a properly completed and timely written request that clearly defines what remains unresolved as a result of the step 1 meeting to include the requested remedies. Labor Relations will schedule a step 2 hearing within 10 working days. And hold the hearing within 20 work days within 20 work days of receipt of the step 2 grievance form. We also made requests to strike the first part of the next paragraph, and we changed or revised to, at the step 2 hearing, the neutral hearing officer will consider all documentation and evidence submitted with the step 2 request, as well as the district's rebuttal evidence. Hear arguments presented by representatives for both parties and have the opportunity to ask questions of the parties. Neither party will be permitted to present new issues at the hearing unless mutually agreed to by the parties. We also are making revisions to the next paragraph. The neutral hearing officer will furnish the employee, the JESPA office, the involved administrator, and labor relations with a written copy of their decision within 10, again, changing that from 5, workdays after the hearing was held. The neutral hearing officer may be granted an extension for good cause by making a request of both the Office of Labor Relations and JESPA. And again, we changed from 5 to 10. For step 3, arbitration, we have changed from transmitted in writing to submitted using a step 3 form within 10 instead of 20 workdays after the JESPA receives the step 2 decision. We made modifications to the Office of Labor Relations or Employee Relations to the Jeffco Legal Counsel assigned and moved from 5 workdays to 10 workdays. And then as we scroll down, we also made a revision within the 5 workdays here. We changed that to 10. And no public release of information may be made until after such a meeting takes place. So we just changed that wording a little bit to make it more clear. And then 12.3, as explained above, we moved all of these definitions up above. In 12.3.1, we are suggesting that we have a grid that shows what type of grievance, what the timelines are, the time to schedule, and the time to respond. This will make it easier for the grievant and as well as the administrators. And then we just changed the numbering after that. Do we have any questions on Article 12? I'll make sure that I redline that 10 that I've made a change in.
All right. If there are no questions on 12 quite yet, we will move on to Article 13, which is our final language presentation for the morning. Let me grab 13. Whoops, that is 12. There's 13. Okay, as everyone is aware, 13 is our transportation article. I think that's large enough for everyone to be able to review. So we have struck the very first portion of Article 13 regarding training. And oh, I'm sorry, go ahead, Darcy.
And I'm sorry to interrupt.
It's okay.
Where it has that parentheses move to PD article.
Yeah.
That's the kind of stuff I was talking about
Got
on
it.
the previous.
Okay,
Just
totally. Can on Article 10, after everything we struck around performance management, can you put that on there? Oh, perfect. Yeah, the same thing. Perfect. Thank you. Great
That's
point.
exactly what I,
And we actually have that later in this article too that says move to appendix. So it's funny that you brought up appendix earlier. I'm like, oh, yes, good point. So exactly, we're happy to continue with that practice.
sorry for the interruption.
No worries, no worries. And so to Darcy's point, this first statement we have struck, and our recommendation is to move it to the professional development article. And that is really specifically because we believe that additional training and refresher courses that are required should be compensated at any employee's regular hourly rate, not just transportation employees, but FNS employees, custodial employees, etc. So in this article, we have modified the numbering, and then our first change is down in 13.1.3. During the course of the contract year or school year, when a route decreases in time, previously it didn't give a specified time, and so we want to make sure that that is specific in here. In the third sentence here, it says additional work may be assigned to the employee to compensate for decreased time. Obviously, when employees are hired, our intent is to keep them hired at the rate and hours that they were initially hired at. Therefore, it might require that additional work be assigned if other work is decreased due to a route change or otherwise. Subsequently, in 3.1.4, we also changed from work offered to work assigned, and of course must be within the typical duties of the employee's classification. In Article 13.2, modification from 12 to 10, the district will continue to employ a minimum of 10 utility driver positions. As everyone is aware, we have a shortage, and being able to employ 12, I think, is becoming more and more challenging. In Article 13.3, we've struck this initial language and rewritten it down below. So this is around the Employee Administrator Liaison Committee. We've renamed it, and we have modified the language and just rewritten the whole thing down below. So 13.4 now reads, Transportation Employee/Administrator Safety Committee. We acknowledge that safety is really important, both to you and to us, and to all of the employees and students, and as well as families that we support. So in 13.4.1, the committee will consist of one terminal director, one transportation employee from each terminal, one fleet employee from each department, one employee from the department, and one member selected by JESPA. So I'm thinking that means one additional employee from the department in general. In 13.4.2, the committee will meet a minimum of 3 times during the school year. The transportation director or the committee may request additional meetings, which will be held during the school year. In 13.4.3, the committee will be an advisory committee, and the executive director of transportation will be the final decision maker. We've added in or changed the language around extra duty boards and labeled it that, and slightly modified the updated time. So extra duty boards will be available, updated daily, and posted at each terminal to allow employees to voluntarily sign up for an extra duty. And everything else is the same. In 13, which would now be 13.6, special trips, we left that the same. In 13, what was previously 13.7, the full-time regular school bus drivers and school bus assistants who work for the district at a minimum of 228 weekdays, et cetera, we have suggested moving that to Appendix A. And to Darcy's point, we've indicated that right here. In 13, what is now 13.8 in our renumbering, vacant positions for school bus drivers and school bus assistants will not be advertised as described in Article 4.1. Vacant route positions will be posted for 3 days within the bus terminal. The vacancy has occurred. If unfilled after 3 days, the vacancy will be posted across all terminals. If still unfilled, the route may be awarded to substitute employees, a substitute employee, based on final selection criteria scores. Vacancies will be bid according to seniority. And then we have struck that final language because it restates it above regarding when it will be assigned to a substitute employee. Under 13.9, we have been more specific with this language to include student safety equipment. And so with regard to student safety equipment, we have added in a couple of additional sections within 13.9. So in 13.9.2, all CDL and non-CDL bus driver and bus driver assistants, or bus assistants rather, are required to use the equipment per federal, state, and district guidelines, and that is documented in student safety plans. In 13.9.3, all pre-trip inspections will be completed according to the district transportation guidelines in their handbook, and all equipment malfunctions will be reported promptly. So of course, for the most part, bus drivers are dealing with equipment and how to keep kids safe using that equipment. And so that's why we've added these two in and made that more specific to what our hopes are for them to complete. And that is all in 13. Any questions on 13?
Can you go back to 13.9, the new one?
Of course. 13.9.
I just don't see that existing at all. So I'm just curious shouldn't that all be new changes?
This part was 13.9.1 was nowhere before?
It's not in transportation. I just want to clarify if I'm wrong, I will happily be wrong, but.
No worries at all.
Okay.
It's probably a misread line.
All good. I just want to make sure we're tracking that as a new.
Every once in a while when you're typing in these, you're in edit and then you're in suggesting, you're like, dang it.
We hear you.
You gotta go back and take it all out. So our apologies. All right, if there are no other questions on 13, I believe we have reached a point where we'd like to take a 20-minute caucus. Is that, yeah? And if the JESPA team needs more time, please feel free to communicate, let me know. And we have caucus rooms set up. Hopefully they're not cold. And otherwise, we will ask Brandon maybe to push the button for us and take us offline. For those of you who are watching online, we hope you are somewhere safe, wherever you have arrived this morning. And welcome to Tanya Lopez. Dr. Tanya Lopez, Director of Professional Learning, has joined us from the cold. Welcome back, everyone, and thank you for your patience as we took some time to caucus and conversation. And so I believe we are ready to move on. Actually, first, I apologize. Do you want to address any questions that you might have about those 3 articles now or after?
Well, we can segue right into something that we talked about.
Perfect. I will turn it over to you.
We are very intrigued with what we've seen and noticing how things need more definition, and you've proposed some things in the actual articles, but some of those things also transfer into other articles, which was what was creating our whole concern, why we needed the little extra time on the caucus for presenting our Article 1. We are hesitant to actually present the article because it is going to be so fluid and ever-changing with everything else that we're doing. We don't want to make it a regressive proposal to keep adding and adding and adding. So what we're suggesting is that we show you where we are out right now, but not actually putting it in the Teams folder as a true proposal. As Amanda, you and I discussed a little bit yesterday, this is going to be the very fluid, ever-changing article, and it just makes sense, I think, to just keep talking about it rather than an actual proposal back and forth, and probably do this article and agree to it last, just keeping our own notes internally, if that's...
Absolutely. I think we are on board with that and completely agree. We don't want to get too far ahead of ourselves with Article 1 and then realize we forgot 4 different definitions that came up throughout the season. And so we are absolutely amenable to that.
And that was a lot of what we need the extra time. I'm like, we can't throw everything in there that we think is necessary because we don't know.
Sounds good. And completely up to you if you'd like to share what you have today. And if not, that's okay too.
We will, but at the end, because again,
sure.
Some of the articles go back to that, so we can show you starting point where we are.
Sounds great.
Just keep that going. Okay, we're going to do this in backwards order. We're actually going to do 8 first, if you have 8.
Okay. Article 8 is leaves. Not a whole lot of changes or suggestions. Under 8-11, we'd like to propose adding all full-time ESPs will be given sufficient hours to meet FMLA requirements. And then, again, some of the numbering that went funky. The 8-7 will be 8-8, 8-8 will be 8-9, 8-9 will become 8-10, and so forth all the way down. And then at the very bottom, we would add 8-16 holidays and propose adding 8-16-1. Employees will receive a number of paid holidays as provided. And there's a chart that we added for the Friday after Thanksgiving to add that holiday to school-based employee bus drivers and bus assistants and paraprofessionals and health techs. And then winter break for all year-round employees, school-based bus drivers, and the paraprofessionals. And then 8-16-2, adding employees working summer programs or extra duty over the summer will receive year-round holidays.
So for instance, as a paraprofessional, if I work summer school, I don't get paid for Juneteenth even though I'm working. Similarly with bus drivers, if they're working, they don't get paid for Independence Day.
Thank you. That was helpful. I was confused because when it says year-round holidays, I thought that it meant people who work in the summer will get the proposed Thanksgiving break holiday, even if they don't work during November.
That's not the intention.
Okay, I just want to make sure that I understood. I was like, wait a minute, if they don't
It's the
work,
intention.
got it. So, and that is referring just to people who work during the summer and or people who work both during the summer and during the full year.
Correct.
Okay, thank you.
And just to clarify on the FMLA, for instance, paraeducators are missing the state requirement by 4 hours. That's why we're saying all full-time ESPs, they don't qualify.
Because they didn't work 1,250 hours the year prior? Because
Correct.
they can't, is what you're saying. They can't work 1,250 hours based on their current number of work days and work hours.
They miss it by 4 hours.
Got it. Thank you. When you say full-time, do you mean 40 hours? Just to make sure I understand.
No tying into the benefits, the 30 hours.
Got it. Okay, thank
But
you.
again, that's where definitions are important.
Exactly. Very helpful. Could you scroll up just a little bit, Vicki? Thank you. So school-based bus drivers, I just couldn't remember how the table was set up. So just to make sure that I understand right now, the school-based employees, bus drivers and bus assistants and paraprofessional and health techs, the reason they are grayed out of receiving Juneteenth and Independence Day is because under that particular job code, they don't work during that time. But if they were to work a summer job, like a school-age enrichment, then potentially they could receive that under year-round, right? Okay. Thank you. I'm sorry, is it okay if we ask any other questions? Sorry. Any other questions from our team on this side? Or clarifications? Go ahead, Jessica.
So in the grid, it says paraprofessionals and health aides, I believe, but you mean paraeducators in there as well?
Paraeducators are considered school-based employees.
Okay.
I just want to clarify too. So holidays currently exists in Article 5. And so we would be striking that and putting it into Article 8.
Only because I can't remember, is the grid currently in an appendix or does it live in 5?
It's in the appendix.
Okay, and is your intent to include it into 8 or to put it in the appendix or both?
Cut it from the appendix, put it in 8.
Got it. Thank you. Any other clarifications from JESPA or questions from the district team? All right, thank you. Oh, sorry, Jessica has one more. Or 4 more.
I apologize if I should know this, but I don't. Can you scroll back up to the grid again? Okay. So paraeducators fall under school-based employees, but paraprofessionals and health technicians don't?
Correct.
Okay. Why?
So historically, paraprofessionals had their own contract.
Okay.
And it got shoved into this contract, I don't even know how many years ago. Okay. So there's a bunch of stuff in the current contract that says excludes paraprofessionals and health techs, okay, because that language then got put into this.
Okay.
So that's the historical.
I think we'd be open to combining all of that. I mean, if it's the same thing, do we really need to have 3 separate columns for that group? We could define that some other way.
Are there paraprofessionals and health techs that are not school-based? Just out of curiosity. To your knowledge? Okay.
Well, there are paraprofessionals who work at the central office, so that's not school-based.
Are there?
And the only reason I say that is I see job postings at the Ed Center for paraprofessionals
Oh,
that work, the
I
work
gotcha.
location is the Ed Center.
Yeah. Sometimes it's because it's like a pool, and like a special education will try to hire and then send people out. But it's a good point. Thank you.
So moving on to, it's still under leaves, moving to Appendix D, which is the sick leave bank. And I'll just give the background on this before we see the language. At the end of last year's negotiation, the sentence was that JESPA will receive the same benefits package as JCEA. Comparing JCEA's sick leave bank language and comparing ours, they do not agree. So these changes are just to tie into what the JCEA language was for sick leave bank. That's where it all came from. The only difference in that is here in 1.1, where it says medical care. The JCEA language says immediate family member, but their definition of family member is different from our definition. So we changed instead of immediate family member to just family member and struck out certain instances in care of child, which was what our language said. So that broadens it and ties in better with our definition of family member. And then again, the rest of this is JCEA language. And I can read through all of it, or
Forgive me for forgetting, but in JCEA, does it say 12,000 hours?
in JCEA it does say 12,000.
Okay. For some reason, yesterday in my brain, it was 30,000. I don't know why.
It's okay.
That's what the balance actually is right now. Who knows?
And, you know, that's why we have these conversations. And so then the other big point would be we don't need to opt in annually. It's recurring unless you opt out, and that's in 1.4. And so obviously it wouldn't be starting spring 2025, even though that's the language in JCEA. We're leaving that open for you to readdress. Unless it is. I mean, who knows, right? Open enrollment is weird.
Any questions from? I know I'm very familiar with this because I sat at the table with JCEA last year to get this across the line, and so I don't have any questions. Sounds good. Thank you.
And again, I was hoping that would. So then if we remove Appendix A, which is just the holiday table, then this will be no longer Appendix D. It will change and so on. But since we don't know if that's the holiday,
I
right?
think it's C.
C, my mistake.
No worries.
So then this would be C, but not knowing if that's going to go through, that's why we didn't change it. In regressive numbering, onto Article 2. 9. Sorry. That is still me. 9. Nice try, Darcy. So moving all of 9.1 to professional learning, Article 14, because that is talking all about training and not necessarily about evaluations. So we didn't think it belonged there. Moving down to the new 9-1, adding verbiage that both parties recognize the need for annual evaluations, because our understanding is that certain individuals are not getting evaluations and haven't for more than Zoom. Aren't getting evaluations and haven't for a handful of years. So just wanted to, I know the top of the article says annual evaluations, but just wanted to reiterate that. And then just some grammatical changes, are to is, because we're changing it to a single purpose. Adding the verbiage using training and coaching after an aim towards improvement and growth, to clarify that there's a process for that. And adding the standard value-based rubric. I don't know why that's not in red. It should be. Evaluations are intended to be constructive and supportive is also new. So those two sentences are new. I don't know if I want to be specific, putting the HR programs website in the contract, just throwing that out there to our members so that they know where to look for it. Moving down to the new 9-2, it's just highlighted. We need to go round and round on definitions on immediate supervisor versus administrator immediately associated with employee. We need to clarify those definitions in definitions, but just wanted to bring attention to that. And striking through school-based employees, because all it says here is evaluations for school-based will be delivered, adding the word and discussed by May 1st. We just want all employees done by May 1st. We think that's pretty equitable. Adding new verbiage into 9.3, that performance evaluations are not a disciplinary action, that disciplinary action is a separate article. Again, tying back into the definition of the purpose for an evaluation. And then going down, again, grammatical changing on 9.4. Changing the title on the next section. It used to say evaluation appeals. That doesn't make sense because the whole article is evaluation, so just appeals. And just saying it's grievable and striking everything else.
I assume that's all of that. Okay.
That is all.
I just want to make sure. I didn't know if there was any more left to scroll. Any questions? I have one. Just to make sure that I am clear in my understanding, I haven't evaluated an ESP for quite a while. I just wanted to make sure, is the values-based rubric that you referred to the current rubric that is being used, or are you proposing a new rubric or an adjusted rubric?
We are not proposing a new rubric. It's the one that's already posted on the site, which is.
And do you feel as though it is relevant enough for both school-based and central or otherwise? Only because you have switched it from school-based employees to all employees, and I just want to make sure that in your estimation that it is reliable enough.
That's a really good question, because it's hard to be broad and specific at the same time. And I know that our supervisors struggle as well. So maybe that's a collaborative working group topic.
Yeah, it's a passion area for me. I agree with you with regard to evaluation and an annual expectation of evaluation. I'll just be real clear that as the CHRO. I completely agree. And so just a thought. It's interesting because I have written in the margins here in my copy, evaluation tool and criteria are important. So it's just interesting that that came up. Any other questions immediately from our group that have come up? I have a note around Article 4431. And I think I was just looking at it as to why I might have had that. In 4431, it says employee evaluations and or discipline are not to be used by the selection committee. And I think I wrote that in connection to 961 with regard to where pay or eligibility for promotions or transfers is negatively impacted, an employee who disagrees with an overall rating or individual marking can appeal the rating to the panel composed. Anyway, I wanted to reference 4431 like in connection to that. So I just wanted to bring that to your attention as something that we might try to further clarify. And so just for reference, because next time I will forget where that is and why I'm bringing it up, but I just wanted to make note of that. Otherwise, I don't think we have any questions.
Okay, so moving on to Article 2. Yes. Okay, this is a big one. And so I'm going to try to walk through it the best way that we have thought to do it. We have struck some things, added some things, but we're also proposing a new article out of kind of existing language and some new language. So I'm going to walk through Article 2, the existing current language and what we're doing, and then I will then go kind of walk through the new article we're proposing that is kind of coming out of this article. So if you have any questions, please ask. I'm trying to figure out how to. Yeah, can we make it bigger? Please, yeah, you just ask us if you need us to make it bigger. Always. Okay, so starting, Article 2 is currently organizational rights. And in the beginning of that article, or 211, we are striking the first sentence, and that will be, we are going to move that into a new article. Go down. In 2123, we are proposing to have a 60-day notice of change in rate of dues from a 90-day notice. In 214, this is just changing punctuation or capitalization of the word president through the whole thing. And then we're proposing 215, and we're a second release position for JESPA. So we basically just took the language from 214, JESPA president, and created a designated JESPA officer release position. All the language is exactly the same. Moving on to, I believe, 218. Sorry, some of the numbering and indentation of this got really funky, so we're trying to just continue to walk through it. So 218 is meet and confer currently. We are proposing to strike that where it exists here and move that language to the CWG portion of this article, so I'll get to that further down. And then we have I believe it's 2173 or 2172, 2171. We have language here that says the district agrees to negotiate with the association any proposed changes in education support staffing ratios. And so we wanted to call out that we are also going to be proposing a staffing article during this process. And so this language right here, we want to move it into a new staffing article. So it will no longer exist here, but we just wanted to call it out. That we're not striking it, we're going to be moving it. And we'll propose that article later in the process here. Okay, moving down into 223. We are proposing to strike this entire article section, pilot programs, and also strike through the innovation waivers language. It's our understanding that I believe is Free Horizon did not get a renewal for the charter, or did not. Vicki, can you jump in here? This one confuses me because I've never had to deal with innovation schools or waivers before.
Well, that Free Horizon is it a recharter or whatever the word is going back to charter school status, and that would be the only innovation school, making this it's like 3 pages of language, not necessary. So.
Thank you. So striking that entire section. I believe except for the opening and closing of schools, because I think that lives in that section. So we would keep that. We're proposing to strike through the reductions in force section here because it's redundant. We have an entire article for RIFs. So but we believe that article covers everything, and having it here would be just redundant. And then, so the next section here for outsourcing, we are proposing to move this language into the new article I will be going through in a moment. So we're striking it here, but there will be language in the new article that we'll go through in a minute here. So now we're on to the collaborative working group. So this language is all the same except for a new addition at the bottom. So the CWG shall be tasked with monitoring compliance with the provisions of Article X, which is the new article, reviewing any proposed changes to bargaining unit work and addressing potential violations or disputes. The committee shall conduct regular biannual reviews at least twice a year of work assignments, outsourcing, and insourcing plans to ensure they comply with the terms of this article. Any findings of non-compliance shall be documented and addressed promptly. If an issue arises that cannot be resolved at the CWG, the JESPA may file a formal grievance. And then the next section, this is just that same meet and confer language moved down. And we tried to capture this in a comment here because we can't make a suggestion on a suggestion because of technology is strange. So this and the law is new language that we're proposing to add into the 2253. Okay, so here's where it gets a little funky. We got to talk about some definitions that are relevant to the new article that we are proposing. And so the new article is essentially recognition, bargaining unit, and outsourcing. That's what we're titling that new article. And so we want to propose updates to certain definitions. First one being the definition of employee. We are going to simplify that to say employee is a bargaining unit member per Article 1.1, which is the new article. And then we are striking the rest of that language, and we are proposing a new definition of bargaining unit. So the bargaining unit shall include all hourly non-exempt employees currently employed or to be employed as education support professionals. Hereinafter, employees in the defined unit will be referred to as bargaining unit members or employees. Excluded from membership and representation by the association are administrative personnel. And so this section here in black is language from that initial definition of employee that we are moving here, but we are going to strike substitute employees. So let me just start that over. So excluded from membership and representation by the association are administrative personnel, striking substitute employees, and then continuing on with confidential employees and temporary employees. Other classifications considered employees shall include mutually agreed upon classifications by the district and association as outlined in Article 315. And then I believe this is the third relevant definition of temporary employees. We are updating that. So temporary employees are those assigned, we are striking to a seasonal, variable, or non-routine schedule, or two. And then, so are those assigned a short-term time-bound job not to exceed 60 working days, and then adding, this does not include summer work or extra duty that a member of the bargaining unit performs. Okay, so now we're going to go back up to the top and walk through this new article. We just had a field day with trying to figure out how to do this one. So let's go all the way back up. So this is, we're calling it Article X for now. Recognition, bargaining unit, and outsourcing. Sorry, I need a drink of water. Okay, Article X1, recognition. This is that first sentence from the initial or original, or the current Article 2 language. The board recognizes the JESPA as the sole and exclusive bargaining agent for the education support professionals employed by the district, as identified in Article 1.7. The district agrees that employees' rights are covered under this contract. X2, bargaining unit work. During the term of this agreement, all newly created education support professional positions, which have not been designated by the district as administrative, confidential, or part of the JCEA bargaining unit, shall be included in the bargaining unit. The parties to this agreement recognize that the duties and work performed by the unit members in the bargaining unit shall be performed only by unit members and shall not be subcontracted or otherwise transferred out of the bargaining unit. X2.2. Any new positions, job titles, or classifications created by the district that fall within the general scope of duties and responsibilities similar to those performed by current bargaining unit members shall be considered bargaining unit work and covered under this agreement. X2.3. The district agrees to meet with the association and attempt to resolve any dispute over the designation of a new position as administrator, confidential, or JCEA bargaining unit. X2.4. If agreement cannot be reached within a reasonable time, the matter shall be subject to bargaining procedures. X3. So this is where we're pulling existing outsourcing language and kind of plugging it into this new article with a few proposed changes. If the district ever considers outsourcing professional services to maintain operations, and we're striking fulfill the work previously or currently performed by employees. And the rest is the same, but we are going to strike for the purpose of this article. And then down, right now it's numbered 2253, but that number would change because of the new article, but we're striking that whole line. And then we have, we negotiated outsourcing language in Article 6.2.1 last year that we would propose to move now into this new section for clarity. So we have it all in one place, but that language is all the same. We're not proposing changing it, we're just proposing moving it. Then down to X3.2. The district agrees to no layoffs, reductions in hours, or negative changes to the employment status of bargaining unit members as a result of outsourcing. X3.3. Outsourced work will be returned to the bargaining unit members if the service is found to be substandard or if the original reasons for outsourcing are resolved. X3.4. The district is required to include specific clauses in all outsourcing contracts that allow for immediate termination without penalty if the contractor violates any terms of the agreement, especially those relating to the quality and standards of work and labor practices. The JESPA must be notified immediately of any such violations and will be involved in the decision-making process regarding the continuation or termination of the contract. I believe that's it. Thank you. Happy to field questions on that one, knowing it was kind of all over the place.
I have one quick question while you're on this section. In that X3.4 that you just reviewed, Sander, it says, let's see. The district is required to include specific clauses in all outsourcing contracts that allow for immediate termination without penalty if the contractor violates any terms of the agreement, meaning the agreement within that outsourcing contract or this agreement?
The outsourced contract.
Okay, I just wanted to make sure, because I just also wanted to make sure that contractors, should they be hired as an outsourced individual, would not be covered under the JESPA contract because they're technically not employees of the district, right? Okay, I just wanted to make sure that that was. Also, in the, I know that this has been kind of like a matter of how do we fix this. Inside of the JESPA bargaining unit, there are some employees who are supervisors of other employees within the unit. When you say administrative, could you expand on what you're thinking around administrative? Because I know there has been conversation in the past around removing the supervisory structure within the unit somehow, or fixing it somehow. And I just wondered if you might be able to expand on your thinking around there.
Can we go, you're referring to the definitions?
It was right after definitions, I think. You had, it actually might be in two places. It said administrative, confidential, or
I think that's in the new bargaining unit definition. I mean that, yeah. So that's existing language that in our contract already. Mm-hmm. Sorry, let me just read it real quick. I mean, what we're trying to make clear here is that we represent hourly employees. Right. So I mean, anyone that is not that, in our view, would be an administrator.
Okay. So some supervisors are like lead technicians, for example. They supervise other technicians. You would not refer to them as administrative because they too are hourly. Is that accurate?
Correct.
Thank you. I know I should know this, but can you help me understand confidential employee?
I know I was looking in the definitions.
We have a definition of confidential employee in Article 1. Yeah.
I think we believe we need to clarify that together because it's been inconsistent in the past. The ones that I know that were classified as confidentials in the past have been like assistants to executive directors, I believe, but it's not always, some are in our bargaining unit and some get pulled out, and there's not really clear reasons why. So it could be that it's not applied consistently anyway, and it's not clear.
Gotcha. I have actually not heard the term before. I mean, outside of the contract. An hourly employee in HR, because they are an HR professional potential.
I would say like if employee relations had an ESP,
Got
they might be confidential. And to what you're saying, Tanya, that it could be someone in HR that has a lot of confidential information that we don't kind of want in both camps.
Okay, that's helpful. What other questions? Sue-Ann? Perfect. Oh, Sue-Ann, don't forget the mic.
That term actually, the more I think about it, it confuses me too, because I think all employees have confidential information, whether it's about like kiddos, families, they might know things. You know, we have certain things as employees that we have to keep confidential, whether you're in employee relations or whether you know something about a child or a family that you have to keep confidential. We all have that. So that term does kind of confuse me a little bit too.
So I'm just going to read through. So we have a definition of confidential employees in Article 1 already. So it refers to someone who assists and acts in a confidential capacity to manage personnel and has regular access to confidential information about future bargaining strategy or changes that the employer anticipates may result from collective bargaining. It doesn't completely clear that up, but it kind of puts us in the right direction.
Yeah, it's kind of a common term in like labor agreements to indicate more of, trying to think how to say this, like the union and management relationships. So I'm trying to find another definition from other contracts, but it's pretty common. I mean, there are people in our bargaining unit now that aren't in bargaining units in other districts, so there's some conversation to have about should there be people that are listed as confidentials that aren't now?
I wanted to go back because Amanda asked about the definition of administrator, right? And so we got to hourly employee. But when we're talking about administrator here, we're really concerned about like JCAA. Anybody who'd fall under JCAA, because there's still that weirdness of people evaluating people in the same bargaining unit. So is that something you wanted to address here? Is there an intention or a thought around who you're including, but then who might be excluded? Because later we get into like evaluations and who's, you know, there was some clause in the evaluation pieces about that you quickly covered, and I probably don't remember very well now, about who's evaluating who. And so does that, I mean, I think when we get to definitions, I think that's super important, and it might be really important to talk about who you're really thinking about including, like as you're expanding or trying to make sure you are representing all the people that should be represented. Are there people that you're representing that you shouldn't be because they're also I think it's sticky. So I just wanted to see what you were thinking.
Yeah, I mean, I think Darcy called this out before, specifically with administrator versus direct supervisor versus immediate supervisor, immediate administrator. There's so many things that around this definition that we do need to really work and clean up what we all mean by it. I think so. In 465, we do have lead positions called out as well. So these are FMs, kitchen managers, transportation supervisors, folks that are involved with potential grievance resolutions, it says, or I think evaluations. And so we do have that. So it's kind of all over the place, but yeah, we hear you. I think we also tried to, the bargaining unit shall include all hourly non-exempt employees. I think that is our kind of the sticking point for us. That's kind of baseline. We want to represent all hourly workers, and then excluding the confidential, the administrative personnel, and temporary workers. I don't know.
Can I go into the weeds a little bit too?
Please.
I think this maybe will help too with what you're asking. The attempt to also further define the bargaining unit and our work, the work that's done, is common in contracts, and it could address some of the issues that we've had. So I wanted to give examples. There have been positions created that are the exact same job descriptions of an ESP. And then for some reason, it's an admin. So what's the difference? And was there any discussion? And whose work is that? And I know there have been some positions that we've been approached that people want to join, and they're not allowed to be in JCEA or JESPA, but they're not administrators, but they're kind of classified as administrators. And they're doing work that arguably could be salaried and not hourly, but maybe we could argue they're hourly positions. And so we're trying to figure out how to draw those lines a little bit more clearly so that we don't end up with just massive chunks of people being pulled out of our bargaining unit and being just, oh, these are administrators now, when they really, under the Fair Labor Standards Act, are hourly. And it's more of a, like, it could be a union busting tactic or just a way to make sure employees are at will and don't have rights, those kinds of things. So that's why we're trying to delineate what the bargaining unit really means. But I think we still need to add definition to what an administrator really should be, so that if really they should be either JCEA or JESPA, that we're clear why.
No, I don't think we have any other questions at this time. This one is a lot, and we're going to need to digest this one quite a bit. But yeah, I mean, I appreciate the reorganization and the proposal for sure.
Can I just add like a kudos in a way? The outsourcing language that we got at the end of last bargaining, that's here from 621, that was a heavy lift, and we got to agreement on it, and it's great. It just conflicts with a lot of what we had in Article 2. And so we just want to align it. But that we all agreed that contracting out is to fill and maintain operations. And the intent is to still post and fill our positions and to keep our jobs within our bargaining unit and move away from outsourcing as soon as we can once positions are filled. That's all really great. And what we're trying to do here is align all of that with the language and just make sure it's clear.
Thank you. We're still in the article where it had all of the innovation. Is that okay? I just want to tell you that I appreciate the thought to strike all of that, because it is a lot of language that would typically live, I think, in an MOU. Should it ever come up. To your point, we had one innovation school, and now we won't have any innovation schools. And yet we do still have language in our district policy that schools can apply for innovation status. So I just wanted to tell you that I appreciate that you recognize that it might not be relevant at this time. And please know that should it be relevant in the future, we're very amenable to writing MOUs when it comes to these unique situations, as you are all aware, with the MOU that we had around school closures. And so thank you. And I just wanted to put that in the room too. Do you guys have one more, or?
Well,
oh, it's one.
It's
a weird one.
One.
Yes.
Most of the definitions were here. I don't know if there's anything else we wanted to point out in one. We did suggest moving public health emergency alphabetically because it's at the end to where it belongs. Minor stuff like that. Okay, I said it.
Actually, the one that Xander just pointed out, 465, could be a consideration, just as we're talking about the lead employees. I don't know how often it's mentioned in the agreement, but just to clearly understand the difference between like a lead and an administrator might be helpful. But I just wanted to note that for future consideration in Article 1 too. Also,
Agreed. Yeah, all of those are given space in definitions, but that's going to be, I don't want to call it a slugfest. I'll use the word heavy lift. That was good. That's going to be some heavy brain power lift after we go through the articles to be consistent. I think that's all we had on 1 then.
But maybe we can make a note of definitions. Is this on? I don't know, maybe we have a notes page that says which definitions we know we need to update that we haven't gotten to yet, just that come up that don't work.
And we could even note it within each article as we're going. If we feel like a definition needs to be added, we could do like the little bracket or parenthesis that says definition for consideration or potential Article 1 definition. Maybe that would be helpful so we don't forget, because we will, because we are human. All right, so we have on our agenda, we have an additional caucus time. Do you feel as though, would you like more time to consider questions that you might have for 10, 12, and 13 as we presented this morning? I think that our team can go either way. We can have a conversation around any additional questions we might have. Tried to ask questions as quickly as they were coming into my brain. Without cutting you off, because at one point I was like, wait a minute, but then I was like, no, wait, wait for the questions. What is your team thinking around the need for additional caucus time this morning?
Yeah, we can take a caucus. How much time do you think?
I mean, maybe 15 minutes just to kind of to go over some language so that we can come up with any additional questions before leaving the table today so we don't forget.
15 minutes sounds wonderful. Thank you.
And we'll also upload the language into the teams during the caucus as well.
Sounds good. And of course, if you have any additional questions on 10, 12, and 13, we can have a mini Q&A session when we return in about 15 minutes. Brandon, if you could take us offline, we promise those of you watching, we will be back soon. Hello, everyone, and welcome back. I realized when we were on our last caucus that I need to say the time because as I left, I thought to myself, we said 15 minutes, but I didn't look at the clock to see what time we left. So
We sat down and went, how long have we been here?
then I set a timer and then I ignored the timer. So apologies if we were gone a little longer than 15 minutes. We had time to have a conversation. We don't have any major questions. I think much of what we wondered about were things that we discussed. For example, the confidential employee conversation and how we might add some clarification to that. The administrative versus hourly employee, even though some hourly employees act in an administrative way, and how we might add clarification to that. But otherwise, I think that other questions and conversations might come up in a subsequent red line when we propose something different or counter that might spur some more conversation and discussion. Did your side have any questions that you'd like to address?
Most of the things you did such a great job explaining that we understand where you're coming from, and I think just countering is the best bet. Something did bubble up that we did not talk about, and I apologize. That needs to go way back when we were talking about leaves, and we talked about Appendix D in the sick leave bank. That again, at the end of bargaining last year, JESPA agreed that we were just going to get the same thing JCEA did, and that was the solution. So that was the sick leave bank. Something that did not happen for JESPA was, I understand that JCEA got 0.6 FTE are eligible for medical benefits for JCEA, but JESPA did not get that. So when you had talked about what is full time, and I said 30 hours, because that's how it currently is, but JCEA has whatever that is, 24 hours. We'd like that too.
Thank you. That's really helpful context. I remember that, and then it happens all the time. I remember it, then I forget it and think, what was that one thing that was left on the table? And that was it.
So that's not written anywhere because that's
right. Is it in the is it in Article 7? Benefits, the benefits article? I kind of assumed it would come up there.
Because it's benefits, and we talked about leaves, but that was sick, and that's just what made my brain work.
Okay.
So if I'm saying it, I'm capturing it, but not capturing it.
Got it.
Throwing it out there.
Thank you. That's really helpful to know. Any other questions that came up about either the articles that we presented or other conversations that we've... Okay. Just for clarification, for today's agenda, I did add Appendix D. Was it D? Sick leave? Not, or B? D, right?
D is sick leave, C is holidays.
Perfect. I added that to the language proposals just so that we would have record of it, that you proposed it today. So if there are no questions or answers to the Q&A section, I think we can move on to the facilitation conversation that you thought that you might want to bring up.
Excellent. So for, open meeting, Amanda and I met yesterday morning just to discuss a little bit on facilitators. I was pleased to hear that she thinks we're doing all right, getting a little comfortable, getting to know each other, how the process works, the back and forth. I believe we agreed that at this time we're not in a need for a facilitator, but are open to, once we get into later sessions, if we get stuck, to be able to bring one in. I believe that's what we agreed to. Is that?
Yeah, that was definitely part of our conversation, and I'm not opposed to moving forward with that. We also talked about the potential other facilitators that we might engage, whether it is one that we've already presented and that you've met with, and we've had an opportunity to meet with. That is Keystone is the name of the company, and they're already facilitating some of our other groups. We talked about potentially engaging them for a short period of time to see how it works should we need to. We also, like Darcy said, we discussed whether or not we should consider or might consider down the road when we get to a point where we might get stuck and aren't able to come to resolution, engaging someone at that time. We also discussed FMCS, which is the Federal Mediation Consultant Services. Conciliation, thank you. Because why not use the word conciliation? Because that makes sense. So weird. We could also request a facilitator from that group. And so I agree. I think we're doing okay. And I appreciate that you are not completely closed to the idea that when we get further down the road, we might need some support with like the back and forth that will happen.
Yeah, and I just wanted to express that we had hesitations because we wouldn't be able to pay for it, which is why we're leaning to the FMCS, because that is a free federal service, which is neutral. I know Keystone has told us repeatedly that they're committed to the process, not to an individual. But if they're being paid by the district, it gives the appearance that it's not neutral. And with kids, we're always taught that their perception is their reality. And so we just wanted to, we're not saying that that's happening, but it's just a possibility. And then if we were to hire a facilitator, then of course that whole agreement needs to be negotiated, which is something else that we need to negotiate.
Completely understandable. So I'll move forward with that thinking at this point. I think we're doing okay with this back and forth right now. And should we need to engage someone, that option will be available. I do intend to reach out to FMCS just to get their availability. I haven't had an opportunity to do that yet. I said to Jen, how do we do this again? Because we did not engage the last time we had a facilitator from FMCS. That wasn't something that we initiated. And so we just have to figure out with our team who does that. But yeah, I think we're in a good spot.
I'm happy that we're in a good spot.
Me too. Okay, scheduling conflict January 21st. Are we ready to move on to that agenda item? I am not sure how this got missed, and I apologize. In the list on our negotiation procedures document that we reviewed and agreed to, there was one date that I missed that got changed. The times got changed when we received the document. And luckily, Janelle Hawthorne, our building manager, was paying attention. And she said, I feel like I noticed a date that got adjusted, and the boardroom's not available. So January 21st, initially we had scheduled 8 to noon, but somehow in that list, it got changed to 9:30 to 1. The boardroom is not available until 1. It has to be, we have to be out by noon. And so I'm just wondering, would your team be amenable to either shifting that date and time to 8 to noon, or would you be amenable to starting at 9:30 and ending at noon? Do you have any idea why that date might have gotten changed?
Because I thought it was 8 and got changed to 9:30. So
Yeah,
it would be a moving it back.
It is 8 o'clock on my calendar.
8 to noon.
Okay, so we will adjust that, and then if needed, if you feel like it's necessary, we can adjust that in the procedures document and re-sign it if we need to. And if not, it could just be an amendment that we made and agreed to verbally.
I don't know if we need to re-sign it.
Yeah, I agree. Okay, so we will shift that one back to 8 to noon in the hopes that it doesn't snow that morning. I know.
Is the stock show still going on? Is it stock show weather?
Probably. Thank you on behalf of Janelle Hawthorne, because she kind of panics when we accidentally make those adjustments, and she's like, wait, the boardroom's not available. So thank you for that.
Yeah, it kind of makes a difference.
And then our final agenda item, our final agenda item is agenda setting for next Tuesday, which is Tuesday, January 14th. And we have a draft.
And joint communication.
Oh, thank you. I forgot about joint communication. Should we do agenda setting first and then joint? Okay, perfect. So for January 14th, we are actually in 4E, I believe. Yes, we are in 4E and we're scheduled from noon to 4. We will be working with Drew to figure out the best way in which to stream that session. I don't know how to yet, but we will figure it out. And if all else fails, we always have the option of logging onto a Teams and recording our conversation for people to view afterwards. But our goal will be to identify a way in which to stream it so people can watch live. So on the 14th, after welcome and introductions, because that's an easy agenda item, what is your team thinking around either new proposals or returning proposals?
I'm wondering if we should just do more articles. Like, again, you and I briefly discussed yesterday. It's much more easy. Boy, that's good grammar. It's easier to redline when we see all the proposals to see how it all works together rather than digging into red lines on a specific article. Again, as we go through this, we're definitely getting fingers into a lot of the other articles. My suggestion would be, again, prioritizing other articles and bringing them to the table.
Do you have any in mind that you'd like to propose bringing from your side?
We have some in mind, but can we do a 5-minute caucus just so that we agree we have?
I was thinking the same thing, like, oh, whoops, we forgot to talk about that part. Yes, let's do that. Brandon, do you want to take us offline just briefly? We will be right back. Folks who are watching online. live. And welcome back, everyone. We would like to offer you the opportunity to share which articles you would like to bring back for January 14th negotiation conversation.
We're proposing 3 and 15, depending on how many you would like to bring, possibly 14 or 6.
Okay.
Not knowing what your...
We did not have any of those on our list, so we have no need to negotiate which articles this time like we did last time. You've listed 3, 15, and then maybe 14 and 6?
Possibly 14 and or 6.
Okay, sounds good. Our proposal, we'd like to bring articles 4, 16, and then if you're amenable to it, we'd be happy to propose a new safety and security article that we've been working on. We know that you two have potentially been working on something as well, and so we're happy to present an alpha if that's okay with you.
I have a thought. We have committees working on some of the bigger issues. Safety is definitely one of them. And I'm just wondering if you would, I think the next one's a daytime session. So we were trying to figure out how to prioritize some of those that have more committee involvement that aren't the people here at night. So we wouldn't have to release a ton of people to hear a proposal. So that's kind of what I'm thinking through. They will be interested in that. Now we could always schedule a meeting and watch it and go over the proposal. What do y'all think? Any thoughts? I think we can hear the proposal. And we'll just need to know that the safety committee needs to be given the information with the bargaining team at the next meeting.
And just for awareness of both our audience and just a reminder for our team, our next evening session, which I want to tell you all how much I appreciate because I do JCA also, and the evenings are going to start getting to be a lot, is scheduled for February 4th. And so the next 3 sessions are all daytime sessions, either 8 a.m. to noon or noon to 4. So yeah, if you're amenable to hearing it, we're happy to share it, and just know that obviously we're open to counter proposals and further conversation within that article as well. All right. So this time Jen did intentionally put district language proposals and then caucus time, and then JESPA language proposals and then caucus time. Please know that we're happy to flip it if you'd prefer to go first at any time. Even if we adjust that the morning up, it's totally fine.
Jen put it down. It's solid.
All right. Any other items that we might want to add to the January 14th agenda besides our exchange of language? All right. And of course, we will add in the joint communication, which we can refer to now if you'd like to complete this week's joint communication. I did start it just because we talked real quick, and then I'm like, I'm just going to start typing. So we can review that together. It is linked in our shared drive, and I'm happy to put it on this. Oh, Jen is already in. Perfect. Jen is going to share it on the screen so everyone can review it together as well if you're not in the teams. So we started with Tuesday, January 7th. The district and JESPA bargaining teams met from 8 to noon. The teams introduced themselves, including their roles. Minor modifications were made to the agenda to include an additional caucus time, facilitation conversation, and addressing a scheduling conflict on January 21st. The district shared proposed language for Articles 10, 12, and 13, followed by a caucus. JESPA shared proposed language for Articles 1, 2, 8, 9, and Appendix D. After addressing immediate questions and a brief conversation, the teams took an additional caucus. And then That's all the farther I got. Is that okay so far? Is it too much? If
I'm
it's
just-
too detailed.
I'm just wondering, do we need to put caucuses in there?
I was thinking the same thing.
It
Right?
just seems weird to me.
I'm just wondering for Article 1, if I don't think we necessarily proposed that language. We just kind of had a conversation around how we are going to go about doing Article 1. So just maybe removing it from there. Cool.
That makes sense. And I agree that it's weird to write in the caucus so many times. Like, readers don't care that we took a break and talked.
Right?
So after addressing immediate questions, the teams engaged.
I don't even know if that whole sentence needs to be there.
Right? I know. I'm with you. Okay, I'm with you.
Same thing up above. Modifications to the agenda. The agenda's posted, right? Or is it?
It's not.
Okay. Like that.
Yeah, I was putting that there for transparency purposes so that if people watch the week before, they'd be like, well, they set the agenda. Why did they change it? But
And that makes sense.
sure. But yeah, we don't have it posted. It's a good point. We could, if, I don't know where, but we could, if that would be helpful.
Further
People
discussion.
will know. Yeah. Jen, can we figure that out? Okay, great.
Think about it, come back.
And so we can, then I'm just going to copy and paste what we wrote last week and adjust the articles that we just said. So after caucus and conversation, the teams return to the table to identify articles they intend to bring to the January 14th bargaining session. And Jen, will you fill in the articles? Thank you. Sorry, they're already gone from my...
And I'm staring right at it, so
Ready. Go ahead.
3,
3,
15, possibly 6 and 14.
I'll just leave that maybe-ish, maybe. Let's see. Possibly.
Potentially.
And then what did we say, Darcy? Sorry.
4,
4.
16, new safety.
Perfect. And so we set the agenda, and then again, for those who are observing outside of our room, we want to remind everyone that the January 14th session is scheduled for 8 a.m. to noon as well. I lie. It is 12 p.m. to 4 p.m. Apologies. And it is in room 4E at the Ed Center. So again, 12 p.m. to 4 p.m. at 4E of the Ed Center.
And then also January 21st, back 8 to 12, not 9:30 to 1.
Exactly. Yeah, we can put that in here too. Which is scheduled for 12 p.m. to 4 p.m. in 4E. In the boardroom. Perfect.
Excellent.
All right. If there are no additional agenda items that we need to discuss, I think we are all set to adjourn for this week. Thank you, everyone. Thank you to those of you who are viewing in another location. Have a lovely day. Stay warm. Drive safe.